There's some interesting history about the informed consent doctrine, legal doctrine in the United States that I wanted to share with you because it's right home for me here in Washington, D.C., where I do a lot of my law practice. And that is the lawsuit, the legal case that pioneered a lot of the modern, what's called common law of informed consent, came from a case right here in D.C. called Canterbury versus Spence. Canterbury was a young fellow who worked as a clerk for the FBI here in D.C. He went to a neurosurgeon named Dr. Spence for treatment of some severe back pain he had, wound up after surgery with a really bad outcome and had partial paralysis from that. He couldn't prove that the doctor had done anything wrong in terms of the surgical technique, but he made a claim that the doctor hadn't told him all the facts he needed to know to make an intelligent decision about the case. And I've got another video on our website that talks about the informed consent doctrine generally. But I want to tell you a little bit about this case because the case was tried in court, the patient lost, and then it went to a court of appeals called the D.C. Circuit Court of Appeals. That's a court that is a very prominent court. It's often considered the second highest court in the country after the Supreme Court, and judges who've served there currently, several on the Supreme Court, kind of graduated from this D.C. Circuit Court of Appeals. I'm thinking of Judge Roberts, Justice Roberts, Justice Scalia, Justice Ginsburg, and there are others. But back in the early 70s, there was a judge on the D.C. Circuit Court of Appeals named Spotswood Robinson. Here's a picture of him. Spotswood Robinson was a lawyer who worked with Thurgood Marshall. That's another judge who went from the Court of Appeals up to the Supreme Court. Worked with Thurgood Marshall on civil rights cases back in the 1950s, including Brown versus Board of Education. Spotswood Robinson was a lawyer down in Richmond, Virginia, a prominent African-American civil rights lawyer. And then he was appointed by President Lyndon Johnson to the D.C. Circuit Court of Appeals in the late 60s, and he wound up getting this case delivered to him that he instantly saw when he saw the facts of the case that this would be a good case to talk about the civil rights of patients to know everything that the doctor proposes to do and what doctors need to do to respond to that right and to fulfill their legal duty to get a patient's quote-unquote informed consent. It's a really interesting decision. I'm going to also give you a link on the website that gives you the whole case in case you're interested in reading it.